Question 1. In a high-stakes environment where multiple challenges arise from the interpretation of ambiguous contract terms, a party to the contract claims that they should not be held liable for damages because the agreement lacks clarity on key performance terms. The contract includes provisions for payment but leaves the conditions of performance vague, and one party insists that the terms must be interpreted based on the context and previous dealings. How should the courts approach the interpretation of these terms under contract law? A. The court should apply the plain meaning rule and enforce the contract strictly based on the written terms. B. The court may use the contextual approach to interpret the terms considering previous dealings in the course of performance. C. The court will void the contract due to its ambiguous terms and lack of clarity. D. The court should apply the mirror image rule and interpret the contract as if the terms had been explicitly stated. Answer. B. The court may use the contextual approach to interpret the terms considering previous dealings in the course of performance. Explanation. In contract interpretation, courts typically use two primary approaches, the plain meaning rule and the contextual approach. The plain meaning rule mandates that the contract should be interpreted based solely on the written words, but it fails to account for ambiguous or unclear provisions. In cases involving ambiguity, courts may resort to the contextual approach, which includes looking at extrinsic evidence like previous dealings, the course of performance, and the trade practices between the parties. The parallel evidence rule can be invoked here to clarify contract terms by considering external factors that may help interpret the agreement. Course of performance refers to how the parties have performed under similar contracts or previous dealings. Question 2. During a critical transition period where existing processes are being modified, a company enters into a contract with a supplier for delivery of raw materials. The contract includes a force majeure clause excusing performance in the event of natural disasters, but the supplier claims that unforeseen increases in labor costs due to a shortage of skilled workers also fall under this clause. How should the court address the supplier's claim? The principles of contract law. A. The court should enforce the contract as written, holding the supplier liable for non-performance despite the labor shortage. B. The court should apply the impossibility doctrine and excuse the supplier from performance due to labor shortages. C. The court should apply impracticability and find that the labor shortage renders performance commercially unreasonable, excusing the supplier from the contract. D. The court should enforce the force majeure, excusing the supplier for any performance issues, including labor shortages. Answer. C. The court should apply impracticability and find that the labor shortage renders performance commercially unreasonable, excusing the supplier from the contract. Explanation. Under contract law, force majeure clauses specifically excuse non-performance due to certain external events, such as natural disasters or unforeseeable situations. However, labor shortages do not typically fall under such clauses unless explicitly mentioned. Applicable doctrine in this case is impracticability, which applies when performance becomes excessively difficult or commercially unreasonable due to unforeseen circumstances. Impracticability does not require total impossibility, just that fulfilling the contract is so burdensome that it would defeat the purpose of the contract. In contrast, impossibility occurs when performance is literally impossible. A commercially unreasonable increase in labor costs might be justify excusing performance under the impracticability doctrine. Question 3. In a multi-location scenario where consistency requirements are crucial, a contractor signs an agreement to build a set of facilities across different states. However, several clauses in the contract include contradictory terms regarding the performance timelines, payment schedules, and quality standards. The contractor claims that one of the clauses, which includes a delay provision, conflicts with another clause requiring timely performance. Should a court resolve this conflict in contract interpretation? A. The court should prioritize the delay provision, interpreting it as the controlling clause that governs performance timelines. B. The court should apply the contra pro frentem rule, interpreting the ambiguous terms against the interests of the party who drafted the contract. C. The court should enforce the contract as written, despite the apparent contradictions in terms. D. The court should enforce the mirror image rule, assuming that the parties mutually agree upon the conflicting terms and require performance according to both clauses. Answer. B. The court should apply the contra pro frentem rule, interpreting the ambiguous terms against the interests of the party who drafted the contract. Explanation. When confronted with contradictory clauses or ambiguities in a contract, the court often applies the contra pro frentem rule, which holds that ambiguous terms should be interpreted against the party who drafted the contract. This rule helps prevent one party from taking advantage of clear language. Additionally, courts will consider the intent of the parties by examining the contract in its entirety and sometimes look at extrinsic evidence to clarify the conflicting terms. The mirror image rule typically applies to offer an acceptance, not contract interpretation. Consistency across different contractual provisions is vital, and courts will attempt to harmonize contradictory clauses to reflect the parties' true intent. Question 4. In a situation where resource allocation becomes a major concern during the performance of a contract, a party to the agreement finds that fulfilling its obligations is financially burdensome due to unforeseen market conditions. The contract includes an option for renegotiation in the event of financial hardship, but the other party refuses to renegotiate despite the clear change in circumstances. What is the most appropriate principle to apply in this case? A. The doctrine of substantial performance should be applied, requiring the party to continue performance despite financial hardship. B. The impossibility doctrine should be invoked to excuse performance due to financial constraints. C. The doctrine of impracticability could be applied, allowing for a modification or discharge of performance obligations due to the unforeseen market conditions. D. The party should seek specific performance, demanding that the other party adhere to the original terms of the contract. Answer. C. The doctrine of impracticability could be applied, allowing for a modification or discharge of performance obligations due to the unforeseen market conditions. Explanation. The doctrine of impracticability applies when performance becomes extremely difficult or commercially unreasonable due to unforeseen events or circumstances. In this case, if the market conditions have changed significantly, making performance financially burdensome, the party evoke this doctrine to excuse its performance or seek a modification of the contract. This is distinct from impossibility, which occurs when performance is literally impossible. Substantial performance refers to a situation where a party has performed most of its obligations, but minor deficiencies exist. Specific performance, which requires the exact performance of the contract, is typically only applicable in contracts involving unique goods or state, not in financial hardship cases. Question 5. In a high-stakes environment where multiple challenges are present due to contradictory representations made by a party during contract negotiations, one party alleges that they were induced to sign the agreement based on fraudulent misrepresentation. They claim that the other party intentionally made false statements about the quality of a product, which influenced their decision to enter the contract. What legal remedy is appropriate for the injured party? A. The injured party should seek specific performance, demanding that the contract be enforced as written. B. The injured party may seek rescission of the contract, claiming that they were induced into the agreement based on fraudulent misrepresentation. C. The injured party is limited to seeking compensatory damages based on the breach of contract. D. The injured party should request liquidated damages as they were not clearly aware of the full finite consequences of their decision. Answer. B. The injured party may seek rescission of the contract, claiming that they were induced into the agreement based on fraudulent misrepresentation. Explanation. Fraudulent misrepresentation is a key element in contract law and occurs when one party intentionally provides false information to induce another party to enter into a contract. If fraudulent misrepresentation is proven, the injured party may seek rescission of the contract. Rescission is an equitable remedy that cancels the contract and returns the parties to their pre-contract position. The injured party may also seek compensatory damages if they can prove harm caused by the misrepresentation. Specific performance is unlikely because it is typically reserved for unique goods or real estate contracts. Liquidated damages clauses apply to predetermined amounts of damages specified in the contract, but are not rare to a claim of fraud. Question 6. During the introduction of new methods where coordination between departments is necessary, a corporation enters into an agreement with a subcontractor to provide services related to the implementation of new technology. The agreement contains a non-compete clause, which restricts the subcontractor from providing similar services to competing companies for 2 years after the contract's expiration. The subcontractor argues that this clause is unenforceable. Which legal principle governs the enforceability of non-compete clauses in contracts? A. Non-compete clauses are always enforceable under contract law if agreed to by both parties. B. Non-compete clauses are enforceable only if they are reasonable in scope, duration, and geographic area. C. Non-compete clauses are automatically unenforceable if they relate to service contract. D. Non-compete clauses are enforceable only in contracts involving real estate transactions. Answer. B. Non-compete clauses are enforceable only if they are reasonable in scope, duration, and geographic area. Explanation. Non-compete clauses are enforceable in contracts as long as they meet the legal requirements of reasonableness. The clause must be limited in scope, duration, and geographic area to protect a legitimate business interest without unnecessarily restricting the individual's ability to earn a living. Courts typically apply a reasonableness test to determine if the non-compete clause is too broad or overly burdensome. If the terms are deemed unreasonable, the clause may be unenforceable. For instance, non-compete clause that restricts the subcontractor from working anywhere in the country for several years could be deemed overly broad and unenforceable. Non-compete clauses are not restricted to real estate contracts or service contracts. Question 7. While analyzing the root causes of sequential problems in a construction contract, the contractor claims that delays were caused by factors beyond their control, including severe weather and shortages of building materials. The contract includes a force majeure clause that excuses performance in the event of unforeseen circumstances. How does the court evaluate the validity of the contractor's claim for excuse performance under this clause? A. The court will automatically excuse performance if the contractor claims that delays were due to unforeseen factors. B. The court will evaluate whether the force majeure clause specifically includes the causes cited by the contractor. G. Weather and material shortages. C. The court will require the contractor to prove that performance was impossible, not just delayed. D. The court will disregard the force majeure clause and hold the contractor liable for delays. Answer. B. The court will evaluate whether the force majeure clause specifically includes the causes cited by the contractor. G. Weather and material shortages. Explanation. The force majeure clause excuses a party from performance when specified events, typically unforeseeable events, prevent or delay performance. However, the court will only excuse performance if the events causing the delay are specifically included in the clause. For example, if contract lists severe weather or shortages of materials as events that excuse performance, the court will likely accept the contractor's claim. If the clause does not explicitly mention these events, the contractor may not be excused. The contractor must prove that the events were unforeseeable and not merely inconvenient. Courts will generally not excuse performance under a force majeure clause unless it specifically addresses the causes of delay. Question 8. In a case where multiple parties have different objectives, a consumer enters into a contract for the purchase of goods and the seller fails to deliver the goods on time. The buyer claims that the delay has caused them significant harm, affecting their ability to resell the goods at a profit. The buyer seeks consequential damages in addition to compensatory damages. Are consequential damages appropriate in this case? A. Consequential damages are only available if they are specifically listed in the contract as recoverable. B. Consequential damages are generally not available in breach of contract cases. C. Consequential damages may be awarded if the damages were foreseeable at the time the contract was formed and directly related to the breach. D. Consequential damages can only be awarded in cases involving real estate contracts. Answer. C. Consequential damages may be awarded if the damages were foreseeable at the time the contract was formed and directly related to the breach. Explanation. Consequential damages are those that arise from the breach of a contract and are typically related to the particular circumstances of the parties. To be awarded consequential damages, the damages must be foreseeable at the time the contract was made and must flow directly from the breach. Example, if the seller knew that the buyer intended to resell the goods and that the delay would harm the buyer's business, the damages from the delay may be considered foreseeable and consequential. Courts may limit consequential damages if they were not foreseeable at the time the contract was entered into or if they are not directly related to the breach. Question 9. During an emergency response where multiple areas are impacted, a city enters into a contract with a construction company to rebuild several bridges that were severely damaged during a natural disaster. The contract includes a provision that the work must be completed within 1 year. However, after 6 months of work, the city issues a change order demanding that the contractor use more expensive materials than initially agreed upon, that the higher quality materials are necessary for long-term durability. The contractor agrees to the change but requests an additional payment to cover the increased costs. The city refuses to pay the additional amount, stating that the contractor is obligated to complete the work for the agreed price. What principle of contract law applies in this scenario? A. Modification of contract requires mutual consent and consideration, so the contractor is entitled to additional payment for the change in materials. B. Impossibility of performance excuses the contractor from the change in materials and the city should bear the cost. C. The contractor's duty of performance requires them to accept the change without additional payment as the change was necessary for the safety of the public. D. The doctrine of frustration applies as the city's change order fundamentally altered the contract's original purpose. Answer: A modification of contract requires mutual consent and consideration, so the contractor is entitled to additional payment for the change in materials. Explanation: A contract can be modified if both parties agree to the modification and if new consideration is provided. In this case, the change in materials increases the contractor's costs, and as such, the contractor is entitled to request additional payment to cover these new expenses. Question 10. A business enters into a contract to purchase machinery from a manufacturer, but before the machinery is delivered, the manufacturer experiences significant financial difficulties. The manufacturer informs the buyer that it may be unable to fulfill the contract on time due to these difficulties. The buyer, concerned that the delay will cause them significant operational disruptions, wants to terminate the contract. Which contract law should the buyer invoke to cancel the agreement? A. The buyer should invoke the doctrine of rescission, which allows for the termination of a contract due to unanticipated hardships. B. The buyer should invoke the doctrine of anticipatory breach, which allows them to cancel the contract due to the manufacturer's failure to perform. C. The buyer should invoke the doctrine of substantial performance, demanding that the manufacturer fulfill the contract despite delays. D. The buyer should seek specific performance, requires the manufacturer to fulfill the contract as agreed. Answer: B. The buyer should invoke the doctrine of anticipatory breach, which allows them to cancel the contract due to the manufacturer's failure to perform. Explanation: The doctrine of anticipatory breach allows a party to terminate a contract before the actual breach occurs if one party clearly indicates that they will not perform their obligations when due. In this case, the manufacturer's notification about its financial difficulties said that it is unlikely to fulfill the contract on time, and thus the buyer can terminate the contract early. Rescission refers to the cancellation of a contract due to misrepresentation or mutual mistake, not the inability to perform. Substantial performance allows a party to claim performance even with minor defects, but it doesn't apply to anticipatory breaches. Specific performance is typically used when unique goods or real estate are involved, when performance is delayed. Question 11. A service contract includes a clause that limits the amount of damages that can be claimed in the event of a breach. The contract states that no party may seek damages exceeding $50,000, regardless of the actual loss suffered. The contract is signed by both parties. If one party breaches the contract and the damages exceed the specified limit, which of the following statements best describes the enforceability of this clause? A. The damages limitation clause is enforceable in all cases as long as both parties agreed to it. B. The limitation on damages will not be enforceable if it results in an unjust or unconscionable outcome. C. The clause is enforceable, and the non-breaching party can only claim up to $50,000 even if the loss is greater. D. The clause is void and unenforceable because it limits damages in a manner that is unfair to one party. Answer: B. The limitation on damages will not be enforceable if it results in an unjust or unconscionable outcome. Explanation: A limitation of liability clause is generally enforceable if it is clear and agreed upon by both parties. However, if the clause leads to an unconscionable result or is found to be unfairly one-sided, courts may refuse to enforce it. This often happens when the limited damages amount is grossly inadequate given the nature of breach or the loss. For example, if the breach results in significant financial harm beyond the stipulated $50,000 and limiting the damages would cause an unjust result, the court may modify or strike down the clause. Therefore, unconscionability is a key factor in determining whether the clause can be enforced. Question 12. A supplier enters into a contract with a retailer to deliver goods on a set schedule. Due to unforeseen shipping delays, the supplier delivers the goods late, and the retailer claims that the delay resulted in lost profits. The contract includes a liquidated damages clause stating that the supplier must pay $10,000 for each week the delivery is late. The supplier argues that the clause is a penalty rather than a legitimate estimate. Damages. Which of the following is the most accurate statement regarding the enforceability of the liquidated damages clause? A. The liquidated damages clause will be enforced if it reflects an estimate of the damages that were reasonably anticipated at the time of contracting. B. The liquidated damages clause is unenforceable because it constitutes a penalty rather than a true estimate of damages. C. The supplier can ignore the liquidated damages clause if the delay was caused by unforeseeable events. D. The liquidated damages clause can be enforced only if specifically agreed upon by both parties in a separate agreement. Correct answer: A. The liquidated damages clause will be enforced if it reflects an estimate of the damages that were reasonably anticipated at the time of contracting. Explanation: liquidated damages clauses are enforceable if they are a reasonable estimate of the actual damages that the parties anticipated would occur in the event of a breach. This is distinct from a penalty, which is unenforceable because it is considered a punitive measure rather than a compensation for the loss. Courts will assess whether the liquidated damages amount is reasonable and reflects the expected harm at the time the contract was created. If the $10,000 per week delay was a reasonable estimate of the loss to the retailer, the clause will likely be enforceable. Unforeseeable events such as shipping delays might trigger the force majeure clause, but do not automatically nullify the liquidated damages provision unless specified otherwise. Question 13. A corporation enters into a contract with a supplier for the provision of raw materials. The supplier fails to deliver the materials on the agreed date, and as a result, the corporation is unable to meet its own customer obligations. The corporation wishes to recover the damages it suffered from the supplier's breach. Which type of damages should the corporation claim? A. Punitive damages, which are awarded to punish the supplier for its breach. B. Compensatory damages, which cover the actual loss directly resulting from the breach. C. Nominal damages, which are awarded when the corporation cannot prove actual harm. D. Restitution damages, which aim to return the corporation to its pre-contract position. Answer: B. Compensatory damages, which cover the actual loss directly resulting from the breach. Explanation: compensatory damages are intended to make the non-breaching party whole by covering the actual losses incurred due to the breach. In this case, the corporation can claim the direct damages resulting from the supplier's failure to deliver the materials, including any lost profits from failing to meet its customer obligations. Punitive damages are generally not awarded in contract cases unless there is egregious behavior such as fraud or malicious conduct. Nominal damages are awarded when there is breach but no actual harm is proven, which is not the case here. Restitution refers to returning any benefit conferred under the contract, not necessarily compensating for losses. Question 14. A contract between two businesses includes a clause specifying that any disputes will be resolved through arbitration rather than litigation. However, one of the parties refuses to participate in arbitration and insists on taking the dispute to court. What is the most likely outcome when the other party seeks to enforce the arbitration clause? A. The court will dismiss the lawsuit and enforce the arbitration clause, forcing both parties to resolve the dispute outside of court. B. The court will modify the arbitration clause to make it more favorable to the non-participating party. C. The court will invalidate the entire contract due to the non-enforceable arbitration clause. D. The court will allow the lawsuit to proceed and disregard the arbitration clause. Answer: A. The court will dismiss the lawsuit and enforce the arbitration clause, forcing both parties to resolve the dispute outside of court. Explanation: courts generally enforce arbitration clauses when the parties have agreed to resolve disputes through arbitration. If one party refuses to participate in arbitration and attempts to litigate the matter, the other party can request that the court dismiss the lawsuit and compel arbitration. Arbitration is an alternative dispute resolution method that the court will typically uphold unless the arbitration agreement is found to be unenforceable, for example, due to unconscionability or a lack of mutual consent. The court will not modify the clause or invalidate the contract solely due to the arbitration clause unless there are significant issues with the agreement's enforceability. Question 15. A company enters into a contract to purchase goods from a supplier with delivery scheduled for the end of the month. The contract includes a clause stating that time is of the essence, meaning that timely performance is a critical part of the agreement. The supplier fails to deliver the goods on the agreed date. What is the most likely legal consequence of this delay? A. The buyer may terminate the contract and claim damages due to the supplier's failure to meet the deadline. B. The buyer can only claim nominal damages since the time was not explicitly of the essence. C. The supplier will be given extra time to deliver the goods and no penalty will apply. D. The buyer may be forced to accept the late delivery without legal recourse. Answer: A. The buyer may terminate the contract and claim damages due to the supplier's failure to meet the deadline. Explanation: a time is of the essence clause emphasizes the importance of timely performance in the contract. When this clause is present, failure to meet the deadline constitutes a material breach of the contract, and the buyer has the right to terminate the contract and seek damages. If the goods are not delivered on time, the buyer is obligated to accept the late delivery and can pursue legal remedies. The presence of the time is of the essence clause makes the timing critical, and the supplier's delay typically results in the buyer being entitled to termination and damages. Question 16. In a scenario where efficiency decreases across multiple departments, a company enters into a contract with a third-party vendor to provide critical technology services. The contract includes a clause that specifies that the vendor must meet specific performance metrics and deliverables, including timely software updates and technical support. However, the vendor repeatedly misses deadlines and fails to provide adequate support, result in significant operational disruptions. What action should the company take to enforce its rights under the contract? A. The company should accept the vendor's performance as is, as the contract does not specify penalties for missed deadlines. B. The company can terminate the contract and seek damages for the disruption caused by the vendor's failures. C. The company should renegotiate the contract to accommodate the vendor's performance issues. D. The company must wait for the vendor to propose solution before taking any further action. Answer: B. The company can terminate the contract and seek damages for the disruption caused by the vendor's failures. Explanation: in this case, the vendor has failed to meet the performance metrics outlined in the contract. This likely constitutes a breach of contract. The company is entitled to terminate the contract if the vendor's failure to meet agreed upon deadlines and provide sufficient support significantly disrupts operations. Additionally, the company pursue damages for losses incurred due to the vendor's non-performance. The contract may specify remedies for breach, including termination and financial compensation, which the company can invoke. Question 17. While managing a hybrid approach where timing issues complicate coordination, the business enters into a contract with an external contractor to complete a project by a specific deadline. However, delays in the procurement of raw materials result in the contractor failing to meet the deadline. The contractor argues that the delay was caused by circumstances beyond their control and claims that the contract should be adjusted. What is the likely result if the contract includes a force majeure clause? A. The contractor will be excused from liability for delays under the force majeure clause, and the project deadline will be extended. B. The contractor will be held fully liable for any delays, as force majeure clauses are not enforceable in this scenario. C. The contractor can request an extension of the deadline, but they will still be held liable for any financial penalties due to the delay. D. The contractor will be excused from liability for delay, but the company will still be entitled to any damages caused by the delay. Answer: A. The contractor will be excused from liability for delays under the force majeure clause, and the project deadline will be extended. Explanation: a force majeure clause in a contract typically excuse performance when external factors beyond the control of the party prevented timely performance. In this case, the contractor is arguing that delays in procuring materials were beyond their control, which may qualify as a force majeure. If the clause includes such circumstances, e.g., supply chain disruptions, the contractor would likely be excused from liability for the delay, and the project deadline could be extended accordingly. Question 18. When developing a solution that must address opposing needs within a contractual agreement, two parties enter into a contract for the sale of goods. The contract includes a delivery deadline, but due to a strike by a labor union, the seller is unable to meet the deadline. The seller invokes the force majeure clause, but the buyer insists that time is of the essence in the agreement, requiring immediate delivery or cancellation of the contract. Which of the following would most likely occur? A. The force majeure clause will be enforceable, and the seller will not be penalized for the delay caused by the strike. B. The time is of the essence clause will override the force majeure clause, and the contract will be terminated. C. The contract will be deemed unenforceable, and both parties will be required to renegotiate the terms. D. The buyer may seek damages for the delay, but the seller is excused from performance due to the strike. Answer: D. The buyer may seek damages for the delay, but the seller is excused from performance due to the strike. Explanation: the The force majeure clause typically excuses a party from performance if an unforeseeable event like a strike prevents timely delivery. In this case, while the buyer may claim that time is of the essence, the force majeure clause would likely excuse the seller from meeting the delivery deadline. However, the buyer may still be entitled to damages for the delay, depending on the specific terms of the contract. The force majeure event, the strike, could be seen as an unforeseeable event that prevents timely performance. Question 19. While analyzing the root causes of sequential problems in a contractual relationship, a software company and a client enter into a contract where the company is responsible for developing a customized software solution. The software repeatedly fails to meet the specifications outlined in the contract, and the client seeks a remedy. The contract includes a warranty provision that guarantees the software will meet certain performance standards. What legal remedy would the client likely seek in this situation? A. The client will likely seek specific performance to force the company to deliver the software as originally promised. B. The client will likely seek rescission of the contract due to material breach of contract by the software company. C. The client will likely seek compensatory damages for losses caused by the non-performance of the software. D. The client will likely seek an extension of the contract deadline as the issues with the software are temporary. Answer C. The client will likely seek compensatory damages for losses caused by the non-performance of the software. Explanation: when a contract is breached by failure to deliver as promised, the usual remedy is compensatory damages, which are meant to make the injured party whole. In this case, the client likely seeks damages for losses incurred as a result of the software failing to meet the contract specifications. Specific performance is common in contract disputes involving goods or services, and rescission would only apply if the breach was severe enough to justify cancelling the contract. Question 20. In a case where multiple parties have different objectives, a joint venture agreement between two companies includes a clause stating that profits from the venture will be shared equally. However, one of the companies invests significantly more capital than the other and expects a greater share of the profits. The other company believes that the agreement is clear and that profits should be shared equally regardless of the capital invested. How should this dispute be resolved? A. The dispute will likely be resolved by enforcing the joint venture agreement as written, meaning profits will be shared equally. B. The dispute will likely be resolved by modifying the contract to account for the differing levels of investment. C. The dispute will likely be resolved by voiding the contract due to an unclear understanding of the terms by both parties. D. The dispute will likely be resolved by imposing a penalty on the company to honor the agreement. Answer B. The dispute will likely be resolved by modifying the contract to account for the differing levels of investment. Explanation: while joint venture agreements often include profit-sharing provisions, disputes like this one can arise if the parties have differing expectations regarding the sharing of profits based on their respective contributions. If the agreement does not clearly specify how to handle unequal investments, the parties may need to modify the contract to ensure that profit sharing reflects the capital contributions of each party. This modification can occur through negotiation or, if necessary, legal intervention. Question 21. In an environment where different components must interact seamlessly, a contract for the purchase of specialized equipment includes a clause requiring the seller to provide technical support for 1 year after delivery. The seller fails to provide the support services and the equipment fails to perform as expected. What legal remedy is the buyer most likely to pursue? A. The buyer will likely seek specific performance to compel the seller to provide technical support. B. The buyer will likely seek rescission of the contract due to the seller's failure to provide the promised support. C. The buyer will likely seek compensatory damages for the failure of the equipment and lack of support. D. The buyer will likely seek liquidated damages for the seller's non-performance. Answer C. The buyer will likely seek compensatory damages for the failure of the equipment and lack of support. Explanation: in this scenario, the failure of the equipment and the seller's failure to provide promised support will likely lead the buyer to seek compensatory damages for the losses incurred due to the breach. Specific performance is not typically sought in cases involving goods, as monetary compensation is usually sufficient. Rescission could be considered. It is more common when a contract is fundamentally flawed or if both parties agree. Liquidated damages are generally only enforceable if agreed upon in advance and if they do not constitute a penalty. Question 22. During a critical transition period where existing processes are being replaced, a company enters into a contract with a vendor for the supply of software that will automate several key business processes. The vendor promises to deliver a fully functional software system by a specific date, but delays in development push the delivery date back multiple times. The company relies on this software to meet regulatory requirements and penalties. What legal action can the company take to address the delays? A. The company can immediately terminate the contract and seek damages for the delay caused by the vendor's failure to meet deadlines. B. The company must continue to wait for the software and cannot take legal action unless the vendor expressly agrees to terminate the contract. C. The company can request an extension of the delivery deadline, but no other legal remedies are available. D. The company should renegotiate the contract to reduce the scope of software project to match the vendor's capabilities. Answer A. The company can immediately terminate the contract and seek damages for the delay caused by the vendor's failure to meet deadlines. Explanation: the vendor has missed multiple deadlines, which may constitute a breach of contract, especially if the delays are significantly impacting the company's ability to meet regulatory requirements. If the contract includes clauses that address failure to meet deadlines, the company can likely terminate the contract, seek damages for the delay. In cases where time is of the essence, the company's legal rights would allow them to pursue such remedies. Question 23. While investigating a complicated issue between different departments within an organization, an employee discovers that the procurement team has consistently failed to follow the approved supplier selection process, resulting in the purchase of subpar materials. The failure to follow protocol has led to quality issues in the products produced by the manufacturing department. What should the company do to address this situation? A. The company should implement a corrective action plan that includes retraining the procurement team and revising internal procedures. B. The company should terminate the employees involved and consider implementing an entirely new procurement process. C. The company should allow the procurement team to continue using the existing process but impose financial penalties on them for the oversight. D. The company should ask the manufacturing department to fix quality issues without addressing the procurement process. Answer A. The company should implement a corrective action plan that includes retraining the procurement team and revising internal procedures. Explanation: the best course of action is to address the root cause of the issue by retraining the procurement team and revising internal procedures. This will help prevent similar issues from arising in the future and ensure that the company's procurement practices are in line with best practices. Terminating employees or not, the underlying issues could result in continued inefficiencies, while imposing financial penalties without addressing the process does not provide long-term solution. Question 24. In a high-stakes environment where multiple challenges are emerging simultaneously, a client and a service provider are involved in a dispute over the delivery of goods. The service provider is late in delivering a critical component that the client needs to meet a production deadline. The contract includes a provision for a penalty if the delivery is not made by the agreed date. What is the most likely outcome if the service fails to meet the deadline? A. The client will be entitled to the agreed penalty but cannot seek any additional damages for the delay. B. The client can cancel the contract and seek a full refund for the amount paid for the goods. C. The client will have the right to seek compensatory damages for losses beyond the penalty, including lost profits. D. The client will need to renegotiate the delivery deadline with the service provider. Answer: C. The client will have the right to seek compensatory damages for losses beyond the penalty, including lost profits. Explanation: while the penalty provision in the contract may apply in the event of a delay, the client is likely also entitled to compensatory damages for losses that exceed the penalty amount. This could include lost profits or other financial losses that result from the service provider's failure to meet the delivery deadline. Penalties are often set in contracts to discourage breaches, but they do not limit the right to seek additional compensatory damages. Question 25. When implementing new protocols in a shared environment, a company establishes a contract with a consultant to develop and implement a new data management system. The consultant agrees to deliver a fully functional system by a specified date, but the company notices that some features of the system are missing and data integrity issues arise. What should the company do in this situation? A. The company should continue to work with the consultant to make adjustments but will not take legal action unless the issues worsen. B. The company can terminate the contract due to failure to deliver a fully functional system and seek a refund for the costs incurred. C. The company should notify the consultant of the issues and demand an immediate fix within a reasonable time frame before considering legal action. D. The company should attempt to fix the eternally without involving the consultant, as the contract does not require perfection. Answer: C. The company should notify the consultant of the issues and demand an immediate fix within a reasonable time frame before considering legal action. Explanation: in this case, the company has received a product that is not fully functional and has issues that could impact operations. The most appropriate response is to notify the consultant of the issues and demand that they be fixed within a reasonable time frame. This demonstrates good faith in allowing the consultant an opportunity to meet their obligations. Legal action can be considered if the consultant fails to resolve the issues within the agreed-upon time frame. Question 26. In a multi-location scenario where consistency requirements are critical, a retail chain enters into a contract with a national distributor to supply products to all of its locations. The contract requires that the distributor deliver products to each location in a consistent manner with no variation in product quality or quantity. However, discrepancies are noted in shipments to several locations, leading to confusion. Stockouts. How should the company address these discrepancies? A. The company should immediately cancel the contract and seek new suppliers for all locations. B. The company should ask the distributor to address the inconsistencies and provide compensation for the losses incurred due to the discrepancies. C. The company should allow the distributor to continue supplying products and make minor adjustments to resolve the issues at each location. D. The company should negotiate a better deal with the distributor based on discrepancies but not take any legal action. Answer: B. The company should ask the distributor to address the inconsistencies and provide compensation for the losses incurred due to the discrepancies. Explanation: in this case, the company's expectations for consistent delivery have not been met, and the discrepancies have led to stockouts at multiple locations. The company should first ask the distributor to address the inconsistencies and provide compensation for any financial losses incurred as a result. This focuses on fixing the issue while preserving the business relationship and ensuring the distributor fulfills its contractual obligations. Question 27. While examining inconsistencies across various units in a large organization, a company realizes that one of its suppliers has been consistently delivering defective components that do not meet the agreed specifications. The supplier claims that the defects were due to the use of new materials that were not previously tested. What course of action should the company take? A. The company should accept the defects as part of the supplier's production process and continue with the contract. B. The company should terminate the contract immediately and seek replacement suppliers who can meet the agreed specifications. C. The company should work with the supplier to find solution, such as renegotiating the contract or seeking repairs to the defective components. D. The company should impose penalties on the supplier for delivering defect goods but not take any further action. Answer: C. The company should work with the supplier to find a solution, such as renegotiating the contract or seeking repairs to the defective components. Explanation: the company has the option to work with the supplier to resolve the issue, either by renegotiating the contract or seeking a repair to the defective components. This approach allows for a potential resolution without immediately resorting to termination, which could disrupt the company's operations. Defects persist, further legal action may be required. Question 28. In a case where multiple parties have different objectives, a company and a subcontractor are involved in a project where the subcontractor fails to meet key deadlines, causing delays in the overall project timeline. The contract specifies that the subcontractor will be penalized for missing deadlines. How should the company handle this situation? A. The company should impose the penalties as specified in the contract and demand immediate completion of the project. B. The company should allow the subcontractor more time to complete the work and waive the penalties. C. The company should renegotiate the terms of the contract to accommodate the delays and avoid penalties. D. The company should terminate the contract and seek damages for the delay caused by the subcontractor. Answer: A. The company should impose the penalties as specified in the contract and demand immediate completion of the project. Explanation: The contract includes specific provisions for penalties if deadlines are missed. The company should impose these penalties and demand that the subcontractor completes the project as quickly as possible. If the delays continue, further legal action, including termination of the contract, may be necessary. Question 29. While managing a hybrid approach where timing issues complicate coordination, a company is working with a partner on a joint project that requires the completion of several interdependent tasks. One of the partners consistently misses deadlines, which puts the entire project at risk. The contract contains a timers of essence clause. How should the company proceed? A. The company can terminate the agreement and seek damages for the missed deadlines. B. The company should continue to work with the partner to try and meet the project deadlines without any formal action. C. The company should request an extension of the project deadlines and waive the timers of essence clause. D. The company should renegotiate the terms of the contract to adjust for the partner's delayed performance. Answer: A. The company can terminate the agreement and seek damages for the missed deadlines. Explanation: if the contract includes a timers of essence clause, missing deadlines can be considered a material breach of contract. The company has the right to terminate the agreement and seek damages for any losses incurred due to the missed deadlines. This clause emphasizes the importance of meeting deadlines, and its violation could lead to significant consequences. Question 30. In an environment where different components must interact seamlessly, a company enters into an agreement with a technology provider to integrate a new system across its various departments. However, after the integration, several departments report issues with compatibility and the system is unable to communicate effectively with legacy systems. The contract includes a provision for system integration support. What steps should the company take in this scenario? A. The company should continue to operate the system and adapt its processes to work around the integration issues. B. The company should request that the technology provider fix the integration issues as per the contract, potentially with penalties for delays. C. The company should cancel the contract and demand a full refund for the integration services provided. D. The company should negotiate new terms with the provider to extend the integration support period. Answer: B. The company should request that the technology provider fix the integration issues as per the contract, potentially with penalties for delays. Explanation: the company should first address the integration issues by requesting the technology provider to resolve them, as stipulated in the contract. This is especially critical if the contract includes provisions for support and penalties related to integration issues. By doing so, the company is utilizing rights outlined in the agreement to ensure the system meets the intended functionality and avoids the need for drastic measures such as contract cancellation unless the provider fails to meet their obligations.